we go. This is our 310 panel, A New Day at the SEC, the macro and micro impact of changes in leadership, priorities, policy, and organization. There have been a lot of changes at the SEC and a lot of ground to cover, so I won't waste any time. Our moderator for this panel is Anita Bandy. She is a partner at Skadden here in DC. Prior to joining Skadden, she served for 17 years at the SEC's Division of Enforcement in leadership roles, including as Associate Director. Next to Anita is Steve Peikin, who is a partner at Sullivan and Cromwell in New York. He leads S&C's Securities and Commodities Investigations practice. From 2017 to 2020, he served as co-director of the SEC's Division of Enforcement. He also previously served as chief of the Securities and Commodities Fraud Task Force at SDNY. On down the line is Lorin Reisner, who is a partner at New York. He is co-chair of the White Collar and Regulatory Defense Practice and a member of the firm's management committee. Lorin previously served as chief of the Criminal Division in the Southern District of New York and deputy director of the SEC's Enforcement Division. Next is Tejal Shah, who is a partner at Cooley in New York. She very recently rejoined Cooley after 11 years at the SEC, where she most recently served as Associate Director in the Division of Enforcement in the SEC's New York office. And at the end is Jay Spinella, who is Senior Managing Director at FTI Consulting, also based here in Washington, D.C. He is co-leader of the firm's SEC and Accounting Advisory Group. He has more than 27 years of accounting experience, including with the SEC's Division of Corporate Finance. With that, Anita, off to you.
Thank you so much. So I'm really excited to have this discussion. This is a part two to a conversation we had last year at this conference, which was called The Day After the Election, and we were all kind of processing, and interestingly enough, my whole outline was based on uncertainty, but the one thing that was certain was that there was no uncertainty, so we all had to kind of try to process what this meant from a policy perspective, and here we are almost a year out, where we have maybe what we don't have in a lot of enforcement cases, we have a lot of shifts in significant policy areas, which we're going to devote a large part of our discussion today on. So getting right into it, during our time at the Commission, we've all lived through the changing of the guard, periods of transition when a new administration takes over. But what we're seeing today is fairly unprecedented in many ways. We're living through the age of executive orders designed to reduce federal headcount, increase executive authority. It remains unclear whether the SEC is going to have a 5-person commission through this tenure. The division is facing unprecedented resource challenges, losing 12 to 15% of its headcount. And on top of that, there's a never-ending shutdown. And there's no current ability to backfill certain key roles, among many, many other challenges that we're going to talk about. So, Steve, I wanted to start with you. You were co-director during Trump 1. I think it would be interesting for you to talk about how you compare Trump 1 versus Trump 2 and how you expect these really dramatic resource constraints and other challenges to impact the program that you once oversaw.
Yeah, I mean, I think the difference between Trump 1.0 and Trump 2.0 is pretty significant and stark. And I attribute a lot to, the president obviously has a completely different perspective on his control of the executive branch and so-called, as they put it, so-called independent agencies. And, at least from my perspective in Trump 1.0, we, were blessed with a chair who was fairly apolitical, and a president and White House that seemed, pretty disinterested in capital markets and in the operation of the agency. So the agency was left kind of alone. We did experience pretty significant resource constraints during that period as well. There was a hiring freeze and an inability to backfill against departures. And so the overall size of the enforcement division when I was there declined from its peak by about 10%. And the SEC has a large landscape that it's expected to police. If something goes wrong, people ask, where was the SEC? one of the great things about being in the U.S. Attorney's Office in the Southern District of New York is nobody ever says, where was the Southern District of New York when Madoff happened, right? But they did ask that question here. And so, one of the things I worried about a lot at the SEC was, it's a big division with a lot of people and a lot of landscape. And you worry, you don't want to be in charge when something big gets overlooked. And, declining resources just increases that risk.
So there's resource challenges, but there's also restructuring happening. The FCPA unit is no longer listed on the website. There's a decision to create these geographic deputies who were former regional directors, so that sort of position, at least for now, has been eliminated. Do you think this is a meaningful change? And kind of breaking down a little further, do you think, RDs had oversight over the exam staff in their regions as well as enforcement staff. Does this signal that this administration wants enforcement to be less involved in exams, have more things be processed through the deficiency notice process as opposed to resulting in enforcement referrals?
So, I don't know. I will say, though, that from a management perspective, it's probably not a bad reorganization. Until this reorganization, the enforcement director had something like 30 direct reports, and people at McKinsey would tell you can't have more than 5. And so it's a very, misstructured division in terms of reporting responsibility. So, it's one of the things that Stephanie and I thought about, was there a way to reduce the number of direct reports, and we never came up with a good idea. Look, I was very surprised to hear about the elimination of the RDs, which were an incredibly important resource for us. And, for some of the smaller offices, I guess it's, maybe it's not necessary to have both an associate running enforcement and an RD overseeing that associate. But, for some of the bigger offices, I think it's a vacuum of management and leadership. In terms of whether it's intended to, create more separation between enforcement and exams, I don't know. I viewed those as relatively siloed, even under the previous structure.
Okay. I want to shift to Project 2025. I'm going to come back to it later in our discussion, but just sticking to resources for a minute. Part of Project 2025, which we talked about last year on this panel, is this revamping of the federal bureaucracy so that more jobs are filled with political appointees. And so there's, a couple of ways to do that through Schedule F, Schedule G. Those are term-limited hiring. But Project 2025 seems to take it sort of deeper down into the enforcement staff, or potentially deeper down into what could implicate enforcement staff, including assistant director levels. And these are positions typically held by career public servants that are not really impacted by political dynamics. And so is this something that you expect to happen? Do you think this is a commission that's moving towards term limits for assistant directors or staff writ large, and what impact would that have?
I think it would be a big mistake. They say an army is run by its non-commissioned officers, and the analog is the assistant director. Really, runs the cases, oversees the staff.
It's one of the most important jobs.
Yeah, totally. And one of the things, in order to do that job effectively, you have to kind of know how the building operates. And so to have sort of political appointees who aren't familiar necessarily with the background and operations of the agency, haven't lived through being a staff attorney, I think would have a significant adverse impact on the effectiveness of the division.
Yeah. I mentioned executive orders, the age of executive orders that we're living through. So maybe Steve and Lorin, both having come from a DOJ background as well, there's the executive orders, most of the significant ones are unquestionably directed at DOJ, but where do you guys expect the SEC to fall? Are they going to fall in line with DOJ priorities? Where do you expect there's going to be differences? Like the FCPA executive order, for example, it's not clear that it's going to apply to the SEC. The SEC may have a prerogative to go after foreign private issuers. And then there's a whole books and records controls part of the FCPA that cuts at the heart of the Exchange Act authority over public companies. So how do you guys think about where this is going?
I'll say just one comment and then give somebody else a chance to speak. But I think that that's sort of the tone of the executive orders, which is shifting away from enforcement based on, undefined regulations and the like, that has to have an impact on the SEC. And I think we're going to see a move away from some of the more creative and aggressive theories that have been in vogue at least under the previous administration.
Yeah.
Lorin?
Yeah, I mean, I obviously agree. You can actually see the commonality in language between some of the executive orders and some of the statements that Chairman Atkins has made. There's an executive order that has the title something like there'll be no regulation by enforcement, or there'll be no regulation by prosecution. And one of the very first things that Chairman Atkins said in his initial congressional testimony is there will be no regulation by enforcement. Enforcement will take place within the statutes and within the regulations. And I think and I know that other panels have addressed this already, but if there is one unifying theme that I think is a takeaway from what Chairman Atkins has said so far, without oversimplifying it, probably is what we're going to focus on is lying, cheating, and stealing in connection with the purchase and sale of securities or the offering of securities. Full stop. I think unless it can be fairly characterized as lying, cheating, and stealing in connection with offer, sale, purchase of securities, it's going to be hard for cases to get approved by this commission. Now, how will that message be incorporated by the staff in their decision making, in opening cases, in making recommendations, in closing cases? I'm curious to hear what Tejal has to say about that. I think it's unclear. As a matter of common sense, you've got to think that the staff is hearing that, and it's going to have an impact on their decision making and their day-to-day activities. But we'll see. I like what Erica Williams said earlier about the staff having a natural incentive to want to make cases. I'll say want to do the right thing. One of the interesting themes that we're hearing about the current SEC is there seems to be an effort in some ways to, constrain the staff a little bit and limit the discretionary decision-making in the staff. It shows you how the pendulum swings. 15, 16 years ago, when I came to the SEC, one of our objectives was to empower the staff, give the staff more authority, more decision-making, more active involvement in core policy decision-making. So we'll see how this all plays out.
That's a perfect segue to Tejal. Tejal, you were most recently at the division, and you worked with this current administration, so your perspective is going to be very valuable. Just staying focused on these process and procedural shifts that we're talking about, what are the biggest areas that have changed versus the things that have remained business as usual? And going to Lorin's point, where are the areas where staff autonomy has been more restricted?
Sure. And so picking up from where Lorin left off, there is definitely more oversight over the staff's decision making than has existed in years prior. And this is playing out in a few different ways, but one significant way is with respect to settlement authority. So this has evolved over the last few years. In general, there's been an effort to try to bring more consistency to the way the division is approaching settlements in terms of both remedies and charges. And so the idea here being that defense counsel negotiating with staff in Fort Worth shouldn't be achieving like a wildly different resolution from the staff in New York versus home office, et cetera. So while I think it's always been practice to go to the front office before starting settlement discussions in large, high-profile cases, it's really now evolved to the point where staff don't begin negotiating settlements with defense counsel until they've gotten a green light from the front office.
Is that the director or the front office?
So there's a whole process in place by which the staff communicates with the front office and hears back, and sometimes there's a back and forth. But it's unlikely that the staff would put itself out there and make a settlement offer to defense counsel without having the backing first of the front office. And then another related dynamic to that that's going on right now, because we are in a new administration and the Enforcement Division is trying to understand where Chairman Atkins stands on various things, is that, the front office is socializing a lot of potential settlements and, the viability of matters in general with the chairman's office and the commission before giving the staff the green light to move forward. So how this plays out on the defense side is that, you could be at the end of your investigation, you could be waiting to hear back from the staff, like expecting to get some sort of settlement outreach, and you're not hearing anything. And what could be going on at the back end is the staff is waiting to hear back from the front office, and the front office is waiting to hear back from the commission.
Tejal, are those conversations going on without prejudgment waivers being given?
No comment.
Well, staying on that topic, I mean, Steve, how do you juxtapose that against your tenure? How much was discussed? And Lorin, you're talking about autonomy to the staff. How much stuff that was happening, the sausage making of the division, was discussed with the commission?
Yeah, I mean, look, Stephanie and I were trying to run a consistent national enforcement program, and we didn't want things to be different depending on which region you were in either. And so I think we made some efforts to centralize some decision making. Probably it sounds like it's much more than we did. In terms of our communications with the commission, we had very limited communications with the commission before, making settlement proposals.
Because of prejudgment, among other issues?
Yes, but also there were some times when we would talk, usually at a fairly high level, with the chair before going out to do something, if we thought that what we were proposing to do might be controversial or in some way, inconsistent with his expectations. But we would never go talk to commissioners before making a settlement proposal or litigation proposal. And generally, we did communicate with them in advance of closed commission meetings. Generally, we had an approach that we would not go change the terms of recommendations to get votes.
Too much of a slippery slope.
Yeah, and I think that stood us pretty well, but made for some tough conversations at times. I think if commissioners think that, our view was staff's going to make the best recommendation we can to commissioners, vote it up or vote it down. And I think we got support for every single one of our recommendations except for one, which stands out of my memory. But there's a cost to that.
And Lorin, how does that compare with your tenure?
Like Steve, Rob Kuzami and I wanted very much to have a uniform national program across the division as a whole. At the same time, we did think it was important to empower the staff as much as we could in all decision making. What we did was we initiated, and I think it still exists today, a national priority case list. So we had 20 to 25 cases that we were looking at very closely from nearly the point at which they were initiated. And in those 20 to 25 cases, we wanted to speak regularly to the investigating staff, find out what they were doing. We implemented our written investigative plan requirement, which was very unpopular among the staff, but an essential part of our management tool. I think it's worked out. I think it continues to be, at least formally, within the enforcement manual. So in those 25 cases, we followed them super carefully. The balance of the matters, we had, our quarterly reviews with the regional directors and with the associate directors. We tracked the cases. They knew it was important to us to have a uniform program, and if they deviated from what they thought was taking place in the rest of the country, they should bring it to our attention. But we were mostly hands-off in those cases until the point of a recommendation, and then we got more involved. We almost never met with the commissioners in advance of the closed meetings and votes on recommendations. That was true 98 to 99% of the time. From time to time, there was a particular case for one reason or another that we thought it was important to speak with individual commissioners, or that they wanted to speak with us about a matter, but that was very much the exception and not the rule. We did meet with the chair on probably a biweekly basis, at least a monthly basis. But again, that tended to not involve the cases themselves, but to involve programmatic issues.
So, speaking of commission authority the commissioners weighing in, we've all heard the policy shift in terms of formal order authority and that delegation that has previously been with the enforcement front office going back to the commission. During my time there, I mean, the policy has swung both ways, where commission wants more say under certain tenures. Other times, commissioners have been fine with granting enforcement front office delegated authority. Tejal, coming back to you, is there anything significant you're observing this time around with this recent shift back for the commission to be weighing in on formal order authority? Are there typical cases that warrant that level and that degree of engagement with the commission? And on the other side of that coin, are there certain things that are just business as usual, like with public companies and regulated entities, like the staff can, I assume, just rely on voluntary requests? I imagine that hasn't changed, but can you talk about what this new shift means?
Right. So I think this is one of those shifts that got a ton of attention. What is this going to mean now that the commission has to authorize formal orders? And in practice, it really didn't have much of a difference. First of all, as you said, the staff can open investigations and conduct a lot of investigative activity without a formal order. And, for registrants, BDs, and advisors, they have to produce documents to the commission, and public companies often do voluntarily as well. Second, even the instances where the staff does go to the commission to seek a formal order in order to start taking testimony or subpoenaing documents, the commission is authorizing them. It's not like the commission is saying, no, we're not going to authorize your request for formal orders. Like, it is pretty much business as usual. It's just adding additional time and process, obviously, when you have to write a memo and send it up to the commission and get it approved. I do think, some people might wonder, okay, does this mean that staff that are conducting investigations without formal orders are potentially going rogue and conducting investigations that would not be consistent with where this commission wants to be? I really don't think that's the case. Each associate director meets with their assistant directors on a quarterly basis. They have a good handle on the investigations that are being conducted by their staff with a formal order or without a formal order. And the associate directors are unlikely to encourage staff to continue working on investigations if they seem wildly out of line with commission priorities.
Yeah. So want to shift to Chair Atkins' recent speech discussing quality over quantity. And Lorin, this one's going to come to you, but Jay, please feel free to add your thoughts. He recently delivered a speech focused on the enforcement program and changing the incentive structure for the staff, rather than encouraging a high number of enforcement cases, which is one of the hallmarks of judging effectiveness of programs that you and Steve once oversaw. Chair Atkins plans to, quote, reward, quote, quality work and judgment on cases to bring, violations to charge, and relief to seek. This seems to be a pretty strong signal that the division is moving away from leveraging settlement in areas that are untested or overly technical, something that we saw in the last administration. What is your takeaway in terms of what this means for cases that are being investigated, impact on settlements? Are just standalone controls cases a thing of the past? And what are the circumstances where a controls case might still be brought under this administration?
Yeah, look, it's hard to criticize the message that quality is more important than quantity. I mean, I remember we said similar things and meant them way back in the day. So that's completely reasonable, fair, and appropriate, I think, as a message for the chairman to be sending to the staff. The more interesting aspect is, how much to read between the lines of that. And I think that the combination of that speech plus some of the congressional testimony that I referred to earlier sort of seems to leave the unmistakable impression that too much creativity in in case theories and statutory and regulatory interpretation is going to be discouraged and deterred. Whether that's a good thing or a bad thing, I don't know. It's a good thing when there is unreasonable creativity and unreasonable judgments being made. It's a bad thing when you're deterring reasonable judgments and creativity that leads to effective policy and enforcement outcomes. A lot of it depends on the timing too. I mean, sorry to wax nostalgic, but when we came in, it was immediately post-financial crisis, immediately post-Madoff. And one of the messages that we definitely received from the chairman at the time and that we communicated to the staff was, messages need to be sent to the financial community that there is going to be aggressive enforcement and that things are, there's a new day in another direction. A lot of it depends on, your view as to what the appropriate way to respond to current economic, capital formation, other circumstances are. But I do think, and I'd be interested in Tejal's view on this, is that, the unmistakable message has got to be to the staff, be cautious in how creative you're going to be in your statutory and regulatory interpretations.
Can I just say one thing about this quantity versus quality? I mean, I hated the fact that we were judged based on the number of cases and the pile of financial remedies. I hated it. But we spent a lot of time on making sure that our numbers didn't deviate significantly from what had come before us. And I remember the chair saying to us one time, I don't care about the numbers of cases. And I was like, you know why you don't care? Because we've made sure you don't have to care. Because, you go in front of Congress and get filleted by your overseers because you're not producing work. That's just something that I think...
But do you think that creates perverse incentives for those, like what you used to call sunk cost cases, right? Like where like a failed insider trading case turns into a 20647. Like how is this commission gonna look at those types of cases? Do you think those get closed? Is there a plus factor for those to be brought?
I agree with Lorin. No one can argue with the idea that you should be focused on quality over quantity. And I think the highest, use of the commission is, scienter-based fraud cases, right? That's the gold standard. But the Enforcement Division has a lot of responsibilities outside of just, theft cases, right? About market structure and the operation of registrants, et cetera. And you can't ignore all those things. I mean, you can't just say we're just going to do offering frauds, Ponzi schemes, and insider trading. You just can't, because the commission will be falling down on some of its important responsibilities. And I think it's, frankly, naive to think that you can say we don't care about the amount of relief that we get and the number of cases that we bring. Because I think that there will be people, in the media and your oversight who will have different expectations.
Jay, do you have thoughts on this?
Yeah, I'm happy to jump in here as well. It's always interesting being the sole accountant on one of these panels amongst some brilliant attorney panelists. But the one thing I've got going for me is 30 years of living these cycles in different administrations. I think for me, we've seen a lot of statements coming out of the commission potentially around the focus on the individual. I think maybe that's a little bit of a misnomer. There's always been a focus on the individual. The question here, and I think this is yet to be determined, is are we going to see a rebalance on maybe the penalties between the individual and the corporate side, particularly with respect to certifying officers and those individuals that certify financial statements. So I suspect we're going to see a little bit of a rebalancing. To say there's a refocus, I think there's always been a focus. We've seen that. Everybody here in this room has worked matters that involved executives in the past, and I think that's going to continue. Maybe lesser penalties on the corporate side. I think everybody here has heard from different administrations that large corporate penalties don't necessarily help investors. It harms investors. And so, again, we may see that rebalance there.
So, Tejal, want to shift to press releases. Like, what's going on there? Like, we are not seeing, you got to go hunting for cases coming out of the division. I was kind of surprised. There was the Vanguard filing, which was, there was a sizable penalty in the retail space, but no press release. Is this another signal that the division isn't focused on numbers?
I think that's definitely a part of it. This division is not focused on numbers in terms of number of cases filed or remedies. I think another thing going on here is something that the chairman spoke about recently at Fordham, changing the incentive structure for the staff and the way he thinks about it. And he wants to, reward staff equally for making the decision to close a case as bringing an enforcement action. And I think in that vein, there is a view that press releases could incentivize staff to bring cases when, they should equally think about closing cases. So I think that's a view, and that could be part of the reason why we aren't seeing press releases.
Mm-hmm.
It's kind of weird, isn't it?
It's weird.
It's like the deterrent effect of the commission's work. You can't bring every case, and so publicizing what you've done is important for a general deterrent message. Right?
I gotta say, there are some things about it I like. Some of the press releases coming not only out of the SEC but other law enforcement agencies had gotten totally out of control, honestly. There was like so much chest thumping going on outside the four corners of the charging instrument that I honestly don't think that this is such a bad decision. Completely agree with the need to, communicate your enforcement activity for the purposes of deterrence. But in my view, there's a professional way to do that based on the allegations in the charging instrument, and a less professional way of doing that. And humble opinion is that things had really shifted.
We had a rule that you could not use the phrase "cop on the beat" in any press release.
That's a good rule. The lit releases and the admin summaries are still being issued, and I think now the press is starting to realize that's where they should be looking.
Right.
Yeah. So let me shift gears to perhaps one of the most significant changes in leadership. We have a division director for the first time in history as a former military court judge who hasn't worked in the security space, but very credentialed in her own right. Do you think that Judge Ryan's background as a judge, and this is for everyone to offer thoughts on, that there's a shift in terms of more weight to the evidence and legal arguments, something that goes beyond a motion to dismiss, right? Sometimes the standard of filing is, people, when I was there, would sometimes think about it, can we survive a motion to dismiss? That's not the best standard. And so do you think this is sort of a shift in terms of, how those kinds of issues are going to be tackled? She's also a Justice Thomas clerk. Is there going to be more focused on constructionist interpretations of, the SEC's rules and statutes? So how do you guys how are you guys processing what's to come and how she might be thinking of things?
Look, I don't know her, so I can't really get inside her mind or Chairman Atkins' mind. But if you go back to Rob Khuzami, the leadership of the Enforcement Division has been trial lawyers for the last 15 years, criminal trial lawyers, and those are people who, I like to think are kind of attuned to evidentiary issues and things like that. So I certainly never thought about case authorization as, will we survive a motion to dismiss? I was like, could we win this thing if we litigate it? And sometimes you bring a case that, you aren't confident that you win, but you at least think you got a fighting chance. So, but in terms of, a strict construction, one thing I know is that she's definitely smarter than me if she clerked on the Supreme Court. So maybe there'll be an uplift in intellectual ability at the leadership level. So I don't know.
Yeah, I don't know her either, but I sort of like the idea of having a judge as the head of the Enforcement Division. She, from everything I've read about her and heard about her, she's a serious person, professional person, thoughtful, analytical. So I'm cautiously optimistic that she'll be a distinguished and successful enforcement director. Look, I draw the obvious inferences that you just mentioned, Anita. Having been a Thomas clerk, she probably is I'm guessing, more of a strict constructionist and more in line with the type of rhetoric that I described earlier that Chairman Atkins used in his congressional testimony and has used in his speeches about, decision-making and the exercise of authority being clearly within the four corners of the statutes and regulations. So, but that's no surprise either, based on the perspective that Chairman Atkins has.
Yeah, the only thing I'll add on that is that it seems like picking an outsider was a conscious pick, and that there'll likely be some ramifications from selecting an outsider. So, for better or worse, like everybody else discussed, she'll be measured. But I think that's a statement, picking an outsider in this case.
Yeah.
Yeah, but when Kuzami and I came in, we were both outsiders. Neither one of us had ever been at the SEC. Before, so 100% correct, but it's not unprecedented either. So
I want to tackle one more policy issue and then tackle some more substantive parts of the program. The other kind of more significant policy shift that we've heard Chair Atkins, not the enforcement director, but Chair Atkins recently disclosed a new Wells policy where he wants process to start earlier, wants more informal engagement, providing potential defendants more time to respond, and access to transcripts. This is an area that's traditionally been left to the discretion of the staff, and region to region, group to group, it vastly differs. I mean, some people are really trigger happy with the Wells. Others provide that informal process and multiple bites at the apple. Access to transcripts, and that's something that I think universally the staff's been very protective of, because quite frankly this is in civil discovery. So that is a significant change. So what are the reactions to this new policy?
Look, I thought that to the extent that there was a retrenchment from the Wells process in the last administration, I thought that was one of the sort of odder policy changes, because I thought it was the most important part of my job, and I liked it. And the opportunity to sit across from your adversary before you go to litigation and hear their best arguments, like, yeah, I'm not interested in that. I mean, who would say that, right? And for the Wells process to be meaningful, the other side has to be able to address your evidence. Now, there may be some, rare instances where, for reasons, you can't share the evidence, but in most cases you can. And if they don't have an opportunity to grapple with your best or worst evidence, then the process isn't a real process. So I think this is a welcome change.
Yeah.
I couldn't agree more. And I just want to read what it says in the speech. So it says, providing the potential respondent or defendant with information about potential charges and the key evidence that forms the basis of those potential charges is critical to due process fairness and transparency. It goes on to say that the enforcement staff, in giving a Wells notice, will provide sufficient information for potential respondents or defendants to understand potential charges and the evidentiary basis for those charges, such as testimony, transcripts, and key documents. That sounds like it's creating a right for defense counsel to essentially demand testimony, transcripts, and key documents in connection with the Wells process. It's almost like open file discovery before charges are brought. Look, I think it's great from a defense perspective. I think it's great from having open, transparent dialogue with the staff. It's probably going to make some staff members unhappy because it's inconsistent with the practice of a lot of regions across the country. But I will say, and I'll be interested in your views on this, I think it's consistent with the emerging policy in the biggest offices within the SEC. I think in the Home Office and in the New York office, reverse proffers, and receiving information and documents and evidence, and in some cases even transcripts, was the way that things were moving over the last few years in any event. So I think this is great because I think it'll lead to better decision making, and it'll lead to greater uniformity across the division.
There's one change to the Wells process which I put in place, which I hope has endured, and that was between August 15th and Labor Day. Because in the 3 years before I got to the commission, I'd been welsed on August 15th 3 years in a row. Now, I hope if Chairman Atkins is listening, he will impose that restriction again.
Let's move on to just like
But
two
can I just say one other
sure.
thing? It'll be interesting to see the extent to which this policy applies in the pre-Wells process.
Yeah.
Because I think many of the same principles apply, and as we all know, there has been over the last few years a shift toward more of a pre-Wells dialogue than a Wells dialogue.
Which has real consequences on a public company.
100%. But it'll be interesting
So-
to see whether this policy is implemented in a pre-Wells context. I don't know what folks think.
So let me just shift to a couple of substantive areas, because Jay, I want to give you a chance to chime in. Speaking of public companies, we've heard this chair say many times that he wants to go back to basics, core areas of the enforcement program. This invariably includes typical accounting and disclosure issues that relate to public companies. It's a meat and potatoes of the enforcement division. I want to dig, though, deeper in terms of what this means for materiality. Is this a return back to traditional notions of materiality? In the last administration, we saw a lot of things bootstrapped into an expanded notion of qualitative materiality, like governance issues, ESG, cyber, you name it. Is this now is materiality now going to be back to basics? Like you look at stock market impact, you look at analyst coverage, you look at guidance, you look at more traditional measures. Is that sort of the expectation? How are you thinking of materiality?
I think it's pretty clear we're going to be back to that view of materiality to the core financial statements. SAB 99 has been around for a long time, 25 plus years. It's foundational. It's the view from what a reasonable investor would deem material based on the total mix of information, but really focused on the core financial statements. With the prior administration, there was this sort of expansion into the ESG world and sort of maybe softer aspects of the qualitative analysis, things like reputational harm, as opposed to kind of that pre-administration and now maybe currently back to that core of trends in earnings, impacts on management compensation, impacts on loan covenants, flipping from income to loss. And so, there's no question that and this was discussed in the keynote, that the ESG world and the focus around, that expanded view of materiality is not something that's going to be this administration's enforcement focus. This is speculation. I actually wonder if there's going to be on continued ESG and sustainability reporting almost an inverse view of materiality, meaning if something is disclosed, you need to substantiate why it's material, whereas opposed to the core financial statements, the argument is always around immateriality. So I think that's kind of an interesting twist that could, present itself, this time around.
Yeah. So the last topic, really quick, that I wanted to cover is something that was covered by Andrew Ross Sorkin in a recent New York Times article. It was really a sobering read where he talks about deregulation. And he says in the article, history offers a blunt reminder: when transformation occurs this quickly, it rarely benefits everyone unless it's paired with transparency, oversight, and regulation. The dot-com boom of the late 1990s was pitched as a democratizing moment too, until it collapsed under a wave of hype and fraud. Whenever access expands faster than safeguards, charlatans rush in and ordinary investors are often left holding the bag. And he talks about sort of this tension between, this commission wants to protect retail markets, but also wants to open up, pension funds to PE investments. And there's a lot on, what happens on redemptions and lockups for, investors that may not be as sophisticated. So where do you guys see this all playing out in terms of this tension with this commission? It's for everybody. I don't know who wants to jump in on it.
I'm sure I could start. So that is definitely a tension. This administration and Chairman Atkins in particular has really talked a lot about opening up the private markets, both in the asset management side and the private company side, to retail investors. But Atkins has also said that kind of has to happen in tandem with making sure there are appropriate guardrails in place to try to protect retail investors. So I think One area where we're likely to see a lot of scrutiny as this, shift happens is more and more around disclosures, like the disclosures around risk, the disclosures around valuation, liquidity. I would expect the commission to be very focused on that.
Who wants the last word? Lorin, Steve, Jay?
I'll say I have one more topic I want to cover. It was covered in the keynote, and I think also in the financial fraud panel. And this is with respect to the 6-month earning, the potential proposal on moving to a 6-month earning process. I agree with everything that was said in those two panels. I do worry a little bit about the law of unintended consequences. That's interestingly the one area of law that I do know pretty well. But things like market volatility, potential impact to M&A activity, because those things are really kind of focused on getting timely, relevant data. Could there be an expansion of M&A activity and taking longer for capital formation? Those are the things that I worry about.
I think we're at time. Thank you very much.
Thank you, Anita.